My name is Charlotte Wethington, and I am recovery advocate for transitions. But more than being a recovery advocate, I am Casey's mom, which actually is the reason why I'm a recovery advocate. I lost my son Casey at the age of 23 to a heroin overdose. And after he died, I needed to find some way to go on living. And I found a purpose in advocacy. That is the way that I have grieved the loss of Casey. I'm a retired teacher of 27 years, and I thought that I was pretty intelligent. I have a master's degree in education, but when it came to the disease of addiction and drugs, I was clueless. I thought as his mom I would be able to get help for him, get treatment for him, as I had all of his life whenever he was sick. That was not to be the case. What I encountered was one obstacle after another, and the biggest obstacle was that he was over the age of 18. And everyone said that he had the right to choose, that we as his parents were trying to take his right away from him. What we were trying to do was give him the right to live, but we couldn't seem to get anyone to understand that. And the mantra that was repeated over and over again to me was that Casey had to want to, lose enough, and hit bottom. I believed that they knew what they were talking about because, after all, I knew nothing about addiction or about drugs. And so I listened to the advice and was waiting for all these things to happen. Casey had managed to get arrested one time that we knew of on drug charges. Casey was released that day, and of course he went back to using, and more overdoses followed. When they released Casey that day, they said that he could receive a summons within 90 days to appear in court. Unfortunately, that summons came the day of Casey's funeral as we were getting ready to leave for Spring Grove Cemetery. It was only after Casey overdosed, not once, not twice, but 3 times, that we were given the right to make some decisions about Casey. And the first decision that we were asked to make was on a feeding tube put in, and we said yes, we did. And then the second decision was, did we want to have a cage put in his lungs to capture any blood clots that might develop? Yes, we did. And then the third and ultimate decision that we were asked to make was, did we want to turn off the life support? And of course, we did not want to do that. But we were given basically no choice because we were told that Casey was never going to be the Casey that he would want to be or that we would want him to be. He was not going to have any life other than the comatose state that he was in. So after 10 days of being in a coma, we decided that we would let Casey go. And so on the 19th of August in 2002, we let Casey go. We made that decision. And on the 22nd of August, he was buried at Spring Grove Cemetery. So after Casey passed, I made a phone call to the court because I wanted to let the judge and the prosecuting attorney know what had been the outcome, and to plead with them that if they had the chance to intervene on someone else that was in the same situation as Casey, that they would do so, and they would help them to get some treatment. So when I called, the person who answered the phone said, after I told her who I was and why I was calling, she said, well, we have a warrant out for his arrest. And I said, well, good luck. He's at Spring Grove Cemetery today. So I continued to talk to her and tell her why I wanted, what I had wanted the court to do. That I had wanted the court to intervene on Casey. Because at that point in time, we knew we weren't going to be able to do that. That without the help of the criminal justice system, there was not going to be any help for Casey. That's all we had. Our hope was hanging on that. And so when I told her what I had wanted the court to do, she said, well, you don't understand how the system works. And I said, well, if that's how the system works, there's something wrong with the system. And I say, maybe that was my moment of clarity. Maybe that was my epiphany, that I decided at that point in time that maybe I could change the system. Maybe I could do something to make the system work a little bit better for people who have the disease of addiction. So that's when I approached my state representative, Tom Kerr, and asked him if he would be willing to sponsor this bill, which became the Matthew Casey Wethington Act for Substance Abuse Intervention. Because now it gives families and friends a tool that they can use so that they don't have to wait until that person hits that proverbial bottom, that they can intervene while the person is still alive. Because the bottom line is this: people have to be alive to recover. And that's what we hope that Casey's Law can do. It can intervene on a person's drug use so that they have hope of recovery. Casey's Law is not a guarantee. It's not a cure. What it is what it says it is. It is an intervention. We have depended on the criminal justice system to act as treatment centers for our loved ones for decades. And they're really not designed, jails and prisons are not designed to do treatment. And we don't incarcerate anyone else who has a disease other than a person who has the disease of addiction. The reason that we're doing this video is so that it can give families information about Casey's Law. I truly appreciate each and every one of these individuals. They have meant so much to the implementation of Casey's Law. And I hope that through this video that you will gain the information that you need to intervene on someone that you love.
Hi, my name's Dr. Mina, or Mike Kalfas. I'm a family practitioner. I'm also an addiction specialist. I've been practicing family practice since 1996 and addiction medicine since 1997. And I got involved in addiction medicine due to my work initially as medical director of the inpatient unit in Falmouth. One of the things that I initially realized when it came to opiate dependency is that there were some differences in the progression of disease. I initially trained in addiction medicine under the old abstinence-based treatment model that is really based on the idea that on the old stages of recovery that patients progress through different stages and they become pre-contemplative and then contemplative, where they see the disease as something that they really want to eradicate. It's something that they want to get through, they want to get rid of. And prior to that, they're in more of a pre-contemplative mindset where their biggest priority is limiting their negative consequences, but really subconsciously they're still in a preferential mindset where they really want to use. They just want to avoid the consequences. And I think that's where a lot of the disconnect occurs due to the rapid progression and severity of heroin dependency. I think a lot of the folks that we're seeing coming in need of treatment because their disease is so serious, they're really coming in for treatment in the pre-contemplative phase, which in the old days we were inclined to wait on pre-contemplatives and really feel that a pre-contemplative was someone that wasn't very amenable to treatment, that they were going to be more reachable when they got to the contemplative stage. But when it comes to this particular problem, they very often die before they get to the contemplative stage. So there has to be a strategy to reach them and address the problem in the contemplative stage, which really poses somewhat of a conundrum for treatment professionals. And so I think medication-assisted therapy needs to be a bigger part of the treatment model, much to the chagrin of many I know. Likewise, when you look at the changes in brain chemistry in that there are changes to the limbic system of your brain. The limbic system is sort of the subconscious controlling part of your brain. That's where instincts, memories, drives, pleasure, that sort of thing resides. That part is controlled by neurotransmitters such as dopamine. That is the main target of the mu receptor that opioids hit, and there becomes an extreme imbalance in that system that's brought about by chronic opioid use. You get fluctuations in dopamine production. One of the main neurotransmitters that's meant to naturally function in that setting are beta endorphins. Long-term opioid use can upset and even inhibit natural beta endorphin production. You're dealing with an organ, and an organ that has the chance to malfunction. When that organ malfunctions, it's not working right. Medications can help it work right, but while it's not working right, and while it's not being medicated, while it's not functioning properly, and in the early stages of the treating it to function properly, it's not making right decisions. I think it's interesting in just about any other medical scenario that you can point out, whether it be a stroke that causes the brain to not function properly, whether it is a head injury that causes the brain not to function properly, whether it would be Alzheimer's that causes the brain not to function properly, whether it be severe depression or psychosis, or that causes suicidality and causes the behavior not to function properly. If I were to become suicidal and put one bullet in the chamber of a gun and put it in my mouth and start spinning it and pulling the trigger, my brain's not functioning properly and I'm acting in an erratic, irrational manner, that for decades there would be no problem with having me legally committed to being treated and placed in the care of medical professionals that would treat me. But up until recently, there was no recourse for my family to do the same if I were obviously acting irrationally when it came to substance abuse. And if my brain were not functioning properly and I were acting irrationally and putting myself in danger, I was demonstrating what was tantamount to suicidal behavior. I was actually protected under the law for my right to act irrationally and endanger myself and other people that I could kill by driving under the influence or by my criminal behavior that I was undertaking to further my habit. And up until Casey's law was passed, the law actually protected my right to do that. And until I broke the law, there was no legal recourse to make me stop. So it was under that understanding that I believe Casey's law was necessary. People that watched their loved ones just completely destroy themselves were given a legal recourse to petition the courts to apply those same set of rules to someone that was watching a loved one suffer at the hands of a brain that wasn't functioning right. To say, look, somebody I care about is being destroyed, being ravaged by a disease, and I would like the court to help me implore them to get the help they need so that they can fix it. And thanks to Casey's law, we now have that ability to seek legal remedy to undertake that task.
Hello, I'm Judge Douglas Grothaus from the Kenton District Court. I've been a district judge now for 16 years. Prior to that, I was an assistant Commonwealth's attorney for 11 years. Casey's law was enacted by the Kentucky legislature in 2004. This is a state law which is valid in all 120 counties. Casey's law was enacted and created a procedure by which a family member or friend can petition a court to order a person into involuntary treatment for alcohol or drug addiction for up to 360 days. This is an extraordinary proceeding in which the petitioner is requesting the court to restrict an adult person's freedom. In order to do this, our United States and Kentucky constitutions are going to require the respondent be given appropriate due process rights. As such, the Kentucky legislature appropriately required that the respondent be appointed an attorney and that he have a hearing on this matter. While the respondent's freedom may be curtailed by ordering him into treatment, this is a civil, not a criminal proceeding. It is the court's responsibility to make sure that the petition and evaluations are done properly and all parties' rights are protected. The court is the finder of fact in the law, and as such, these are tried to the bench. There is no jury trial in these matters. A Casey's Law case is started by filing a petition in the circuit court clerk's office in the county where the respondent resides or is located. The petition must state why the petitioner believes the respondent suffers from alcohol or drug addiction, must also state why they believe he is a danger to himself or others, and that they believe they can reasonably benefit from the treatment. The petition also has a section which would require the petitioner to select whether they wish the court to order the respondent into treatment for up to 60 days or up to 360 days. I would then advise that the petitioner ask for up to 360 days. That would give the court and the treatment provider as much leeway as possible depending on the recommendations and the evaluations. The law provides that upon filing of the petition, the court shall set a hearing within 14 days, notify the respondent, and cause the respondent to be examined by 2 qualified health professionals, one of whom is a physician. When we started hearing Casey Law petitions, we began seeing some recurring issues and problems. To address these issues, my practice and my recommendation to other judges is to summon the respondent to court as soon as possible. In Kenton County, we hear Casey Law cases every Wednesday. Once we get the respondent before us, whether before or after the evaluations, we appoint them a public defender. After I inform the respondent of his rights under Casey's Law, and after he has a chance to consult with his attorney, I inquire whether or not the respondent is willing to stipulate that he needs treatment. If so, the evaluations can be bypassed, and the court can then order the treatment at the first status hearing. If the respondent is not willing to stipulate, then I order the defendant to cooperate in scheduling and attending the evaluations with petitioner. We then schedule a final hearing. In order to compel the respondent into treatment, the court must make the following findings: that he suffers from alcohol or drug abuse, that he presents an imminent threat of danger to himself, family, or others, or there exists a substantial likelihood of such a threat in the near future, and that he can reasonably benefit from treatment. Again, the petitioner is responsible for arranging treatment and should have, if all possible, prearranged that treatment prior to the final hearing. The other big issue that has come up is the guarantee of payment. The petitioner, when he files the petition, must sign a guarantee of payment which is attached to the petition. This guarantee of payment says, quote, "By my signature below, I do hereby assume responsibility for and guarantee payment for all costs incurred on behalf of the respondent for all alcohol and other drug abuse treatment, including but not limited to initial examination and transportation costs." So because of that, I encourage the petitioners to investigate several things before filing. Is the respondent covered by insurance? Whether that be respondent's own medical insurance, parents' insurance, are they Medicaid eligible? Is there an employer program available, whether that be the petitioner's employer or the respondent's employer? Are there other government assistance available, such as through HUD or VA benefits if the respondent was a veteran or if a parent had served in one of our armed forces? Respondent is now ordered into treatment. Now what? Many programs require the respondent go through a detox program prior to their admission. In Northern Kentucky, we have several detox programs, such as transitions and many other programs. Another option, depending on the circumstances of the respondent, unfortunately, is jail. I know it's hard to see a loved one sit in jail or be in jail, but bailing them out, whether that be in a criminal case or in contempt on the Casey's Law, may be the worst thing you can do. Many of those persons that are addicted, if bailed out, tend to make their legal situation much worse. However, if they are in jail waiting treatment, we know they will be alive, we know they're not using, and we know they're not reoffending. So sometimes jail may be the best place for them when they are waiting for their bed at the treatment facility. What happens when they fail to comply with the court's order of treatment? This is one of the major benefits of Casey's Law. It gives the court the hammer. And by the hammer, I mean the contempt powers. If a respondent fails to comply with the court's order, he may be sentenced to up to 6 months in jail. If I find someone in contempt for failing to comply with treatment, I status their case every 3 weeks to see if the respondent is ready to go and cooperate with treatment. Sometimes they are, sometimes they're not. Sometimes it takes 3 weeks, 6 weeks, 3 months, 6 months. But while that loved one is in custody, they're becoming clean, they're thinking clearer, and it's amazing the transformation that we see in a very quick time from when they are first lodged in custody. My tips for the loved ones. Addiction does not discriminate. Do not let the embarrassment of a loved one who is addicted deter you from seeking help for them. Families that have never been through these issues tend to try to solve them themselves because of that embarrassment, or they don't want to get their child in trouble. They do not report the thefts. They pay off the debts, the bad checks. They get the jewelry out of pawn. My suggestion to you is file for Casey's Law sooner rather than later. Better to have your loved one before the court for involuntary hospitalization than a felony criminal charge. Do not enable the user. When they steal from you, file the misdemeanor charge, along with the Casey's Law if necessary. Stop it early. If you're going to pay for treatment, make sure it is the appropriate program for that addiction. Don't waste your resources on a program that is destined to fail. That is where your treatment provider or your evaluator can assist you in recommending the appropriate treatment. Casey's Law has and will continue to save many lives. Use it, and use it sooner rather than later.
Hello, my name is Kimberly Wright, and I am the mom of a heroin addict. I have a daughter who is 25 years old who was using heroin on a daily basis. I tried other avenues to get her into treatment. She would not agree to go into treatment. Just from speaking to the doctor that was in the ER that night at the hospital, he let me know that my daughter was using mass amounts of heroin and that if I did not get her into treatment that she was going to die. I knew immediately that I needed to file Casey's Law, that it was my last option to try to get her help before she ended up overdosing. So that's what I did. First, I pulled it all up online and I read about it and tried to familiarize myself with it. So I went to the clerk's office. I filed all the paperwork. I myself found free detox and free rehab and got those things into place and got my 2 assessments into place before my daughter was served. Well, when you file the Casey's Law, which I did not know this when I walked in, the parent also has to hand serve their child an affidavit for them to appear in court. The sheriff serves them a copy of the petition, and they also receive a copy in the mail. But I had to serve my daughter first, and when I served my daughter, she absolutely was not very happy with me, that I had did that and I was forcing her into treatment. As far as the court proceedings, it really wasn't that bad. From there, she had went into treatment. I was granted 360 days, and she is currently 7 months clean today, and she is also around 6 months pregnant. Actually, probably the first 2 weeks, she was very, very angry. She would call me from jail. She would be cussing. I would hang up on her. She would call back, and I just told her, I said, you're not going to talk to me like that. If you start that, I'm hanging up the phone, which I did. By the 3rd week, I could tell, she was coming out of the heroin fog a little bit. That's how we describe it, that they're in a fog. They can't really think for themselves or make decisions for themselves. By the 3rd month of her, being in treatment, She did approach me. I had to attend 8 family meetings with her at the rehab that I put her in. Probably by the second meeting, she hugged me and kissed me, and she told me, she said, "Mom, I was mad at you, for filing Casey's law on me, but now I'm not, and I know that by you doing that, that you saved my life. If I would have continued, to be out on the street, I would have ended up dead with the amount of heroin that I was using." Some of the problems I see with parents filing Casey's law is when they go to file the petition, a lot of times they'll have their 2 assessments in place, but they will not have their detox and their rehab place ready for their child to go to. I always suggest to my parents, the parents that I help file Casey's law, to have not only both assessments in place, but also to work with the rehab and the detox to have your rehab and your detox in place in order for them to order your child to go into a detox and a rehab. They have to know the name of the places so it can be wrote onto the order that they're going to order your child, that they have to report to this detox, and after detox they have to go to this rehab. That's actually wrote onto your physical order of your Casey's law petition once the judge orders that. There is a paper that you do have to sign saying that you will be responsible for the cost, and that's one of the reasons that I help my moms to get the free rehab and free detox in place before they go to file the Casey's law petition, so they know that when they sign that, their stuff is already in place. They're not going to be charged for anything because the rehab and detox are already set up and in place for them. Another misconception about Casey's law is that it costs a ton of money, which is not true. I help parents every day find free rehab and free detox for their children. So there is resources out there available. I've probably helped 30 moms or more get their children into free detox and free rehab. And we see this a lot. The parents' concern is, well, my child's going to be mad at me. They're never going to forgive me. And what I tell my parents is, when your child was little and they were sick, you would take them to a doctor and have them treated. And every one of them will say yes. Well, heroin addiction is no different. When your child is sick, Casey's law is there to help you to get your child into treatment so they can get better.
My name is Holly Daugherty, and I'm an attorney in Northern Kentucky. And I learned about Casey's law through my own personal experience with my son, John. He was suffering from alcoholism back in 2010. And as parents, we did not know what to do, where to turn. And a very dear friend of ours who is in AA told us about Casey's law. We learned that as parents, we could file a petition in the county in which we live, petition the court to have John involuntarily admitted into treatment for alcoholism. I had to file a petition with the county attorney's office. They found probable cause that he had a severe problem. A lot of people say, well, if the person doesn't really want to go, then treatment is not going to be successful. And I'm here to say that that's not true, that my son has been sober over 4 years. And now I'm an advocate for families and parents who also have the same kinds of problems with their loved ones. You don't have to be poor. You don't have to be homeless. This law is statewide and benefits anyone who qualifies under the statute. What I find when working with families is they don't know about this process, or they're so overwhelmed by the process that they need someone to help navigate them. And that's where I come into play. My law firm, we do this pro bono as a payback for the success that we had. And we get referrals from Charlotte Wethington, and we just help the parents navigate the process, make sure all the forms are filled out correctly, make sure that they have a medical doctor fill out one of the forms and the qualified health professional for the other. And we go to the court hearing with them. A lot of times we'll try to talk to the loved one to see if they would be willing to just agree to go. So it's really just a hand-holding more than just more than an attorney role for me. So I always tell parents to just put it all out there, whether they've committed crimes or whatever. This is a private hearing. No one's going to know about it. But you really want to show the judge that this is a real problem and this person is in danger. They could die. Normally there's no filing fee involved. You do have to sign on the form that you will pay for the individual's treatment. However, there are so many free treatment facilities that usually, in fact, I've never had a parent or a loved husband or wife have to come out of pocket for treatment. I can say that when I filed the petition for my son, it was August of that year, and I was only the second petition that they had in that year. And I know now the courts are hearing probably 5-6 cases a week, if not more. So I just hope that with this video, parents and loved ones will understand that there is hope, there is a way, and Casey's Law is a way to get treatment for a person who's suffering from addiction.